I'm Les Wilkinson.
And I'm Andy Magruder.
We're with the law firm of Wilkinson and Magruder, your Social Security disability attorneys located in Augusta, Georgia.
Les, as you know, last year Social Security changed the regulations and rules regarding the submission of medical evidence on a Social Security disability SSI claim. And these rules have had a big impact in terms of how attorneys have to prepare cases. Can you please explain the new rules to our listeners, please?
Glad to, Andy. The new rules basically say if you've got medical evidence or evidence you want the judge to consider in your case, the evidence must be in 5 business days before your hearing. And if you don't have it in by then, there's a couple of options the judge has. First of all, he doesn't have to consider it. Second of all, he can postpone your hearing so that he can look at it and make a decision and consider it in your case. Now, what happens then is that might delay your case several more months because the judges set forth these hearings. They give you 75 days notice of the hearing, and so if they have to continue it, it's at least another 75 days before you'll have your hearing again.
And Les, didn't they also, when changing the rules about submitting the evidence, also created some new rules regarding notification of the judge regarding evidence?
Right, and if a lawyer, either Andy or I, know of information or medical evidence that's not going to be submitted within 5 days, we have to notify the judge in writing of what the evidence is, what efforts we've made to collect that evidence, and then the judge will make a decision whether or not to accept it when we get it or whatnot. So,
yeah, and let me ask you, Les, how does this impact how claimants should look at attorneys and who they might want to hire to represent them on a Social Security disability claim?
Obviously, a claimant needs to hire an attorney who knows what he's doing in this area, because when we get to medical evidence, first of all, when we get notice of the hearing, we or our secretaries or paralegals call and make sure, said, what doctors have you been to? We'll go over the list of doctors that we know about. And what we find, not so much now, but it used to be that the client would come in at the last minute and say, oh yeah, by the way, I went to Dr. So-and-so. And you say, well, when did you go to Dr. So-and-so? Oh, about 2 years ago. What was that for? And it'll be more than for just a cold or virus or something like that. It would be something significant relating to their case. And we'll say, why didn't you tell us about this before? And that's why it's important for the clients to let us know of their medical providers, like the medication, in plenty of time so we can get the records, because the burden's on the claimant to produce the evidence showing that they're disabled. And that puts the burden on us as your attorney to make sure we get the evidence in. That's why the 5-day rule is very important.
And again, that's 5 business days. The records have to be in, not 5 regular calendar days, correct?
That is correct. So, that's, if your hearing's on a Friday, then you might say 5 business days. Well, it should be on the prior Friday, because that'll give 5 business days, Monday, Tuesday, Wednesday, Thursday, and Friday.